I think the most important lessons I would say the Sudanese brothers and sisters should learn is one, is that community involvement in the transitional justice process is quite important. It is what organically can make the process valid. And in absence of that, it becomes a top-bottom approach, which in the long run may fail to be implemented. So from the Ugandan context, I think we have seen that civil society groups and different other groups have worked together with government right from grassroots up to the national level. We have seen also the emergence and development of a civil society organization that are equitably represented in all these conflict areas and pushing their voices through up to the national level. And through this process, they have been in position to have policy that is context related and therefore relevant for implementation. The role of civil society has been very relevant. First of all, in terms of helping to document violations and abuses, though not to the standard that is required, but I think to a greater extent, they have had very impactful process towards the transitional justice policy adoption. And of course, we have also seen that in terms of the role of accountability, there has been a cry out there that there are certain crimes that were bigger than everybody else. And the only thing to do was to move to the higher court, to the international court. And of course, on the issue of reparation, you have seen citizens going to court. So somehow, the process of going to court has been an important lesson in catalyzing, speeding up the process of adopting the policy. And right now, government is in the process of introducing a bill in parliament. Well, the transitional justice policy came about through many processes. One, the formation of the National Transitional Justice Working Group that was created by the then principal judge, arising from the signing off of the Agenda Item 3 on accountability and reconciliation in Juba. That is what sparked off of that process. And through that, we had to do a lot of internal lobbying and advocacy by CSOs. Actually, the success of that policy has been on the role of the CSOs. Constant pressure, constant training, because what we discovered was actually the total ignorance of the various line ministries that were supposed to be involved in the process. Now, through these capacity development programs of the Ministry of Health, of the Ministry of Internal Affairs, of Ministry of Justice, of Ministry of Information, Ministry of Education, all of them came to learn that actually they were very relevant to the participation and the process of adoption of the policy. So at the end of the day, we had to do what we call a country-wide consultation through the Ministry of Justice, working together with civil society, and also through what we call Uganda Law Reform Commission. They also had parallel studies on in traditional justice, they did on accountability, they did on reparation, and all these studies informed government in such a way that it became inevitable for this policy to go through cabinet, and cabinet to be well educated, because there was a whole retreat of cabinets to inform them about what they mean by transitional justice. Now, through that, it became so easy to adopt the policy. Actually, the president said, we should have done this a long time ago. And right now, the bill is soon coming to Parliament. I was actually the one who should have moved that bill in the last Parliament, but we ended up adjourning that Parliament. So I'm happy that my former MP, with whom I replaced, is now the Minister of Justice. So he's the one in charge, and he's going to table this bill. A former victim as well. So it's quite amazing that the transitional justice policy will now have a very firm foundation with a new law that will facilitate its implementation. Well, the ICT in Uganda has been an experiment where you, without even the policy, you are already rolling out implementation. An experiment which they had to use what they call the Court of Judicature Act, which gives powers to the principal judge to create a division. And it was quite an innovative approach that they put in place, that put in the division, that at present is beginning to be fully funded and now moving in to begin trying the current gentleman called Yellow, which we never believed would take on. Over 8 years now, he has been on remand. And the issues of amnesty has also been a challenge. Government has been extending. So for me, the ICD has been a deterrent domestically for many of those perpetrators. So the mere fact that there is now an established war crimes division is enough lesson to deter future perpetrators. So it is a plus for the people of Uganda, but of course it remains to be functionally facilitated. We have to work out a way of ensuring that they have the budget to facilitate their implementation processes. So it is in a way reducing the issues of complementarity. We already have a domestic mechanism that is as strong as the ICC that only needs strengthening and facilitating. Well, the judges are there of international repute. So I think it is good progress. I think for justice to remain relevant and close to victims is about the timeliness or what I call the response or the turnaround response by government in dealing with some of the emerging issues that do not need all this time to be taken. I've seen from when some of the violations happened, the victim had to move many times through advocacy of CSOs, through petitions to Parliament to ensure that their issues are listened to. I remember actually putting a motion on the floor of Parliament on the issue of addressing the issues of women who were abducted and their children born in captivity, like in the DRC and in Sudan bushes, so that government, in the meantime, could respond to support them. And this motion had, at least government came out and said, while we wait for the bigger issues to be sorted out, let's in the meantime support these women on the issues of return and taking their kids to school, and also giving citizenship to children whose fathers actually raped these young girls who produce in the bush. So through government now we had to have the National Registration Bureau in charge of citizenship to come on board to actually take over these kids. They were stateless. But the bigger challenge remains, as long as the bill or the law is not in place, the policy cannot work on its own. We need a law that facilitates the implementation of the policy. One of those pillars of our community-based justice system that were ignored when the colonial power came. Our traditional justice mechanism should be secondary to the common law, which was the British law. So in a way, because of the complex colonial management, we were made to appear secondary. Now in Uganda, traditional leaders were at the forefront of working with government to restore peace. That is when government acknowledged that let us study this traditional justice mechanism. Why is it that it helps communities to move on, for communities to have resilience, to recover from very serious situations of war? So the end result of this study, which was conducted through the Uganda Law Reform Commission, actually informed government that alongside formal justice, you need to complement it by the introduction of traditional justice mechanism. And I'm so happy that in the new law, the proposal is that traditional justice mechanism will work alongside the formal justice system. And in cases of land conflict, it will be the cultural leaders to take lead on handling land conflicts. If it goes beyond them, that is when they can make a referral to the high courts. So in a way, we are beginning to see the recognition of our customary laws into a bigger, into the old jurisprudence that appear to be so Western, now coming on fold to be part and parcel of a new progress of customary law. So that is what is going to inform and even catalyze many state parties in Africa to learn, to come and benchmark from Uganda and see how they can have this in many of their jurisdictions. So I see it as one of the best new development in Africa's jurisprudence. So this is the complexities of the debate. And I see that the more we continue to debate, the better that we perfect the system. That in African traditional societies, like in northern Uganda, the laws, they believe that if you kill the person, the entire community from where you come from are responsible. So there's collective responsibility, which is not individual. And therefore it is even heavier than having individual punishment. Because in this circumstance, if one of your members killed another member, the entire clan will be subject to a traditional trial. And if they find out that it is true he killed, the first thing to do is to ensure that compensation is done for the life that is lost. And that means a bull and 2 heifers must be handed over to the other side. And then secondly, there must be a marriage process that eventually should take place that should rebuild the two communities to come together by reproduction of children. And then 3, it is important that when such thing happens, there's what they call drinking of the bitter root. Now, this plant the root is so bitter that in other normal circumstances you cannot drink. You can't. But you are committed as the perpetrator to drink this bitter root together with the other side. And then they bring a sheep, a white sheep, 2 of them, that is given first, the 2 will face each other, and then they are all cut into halves. The other group takes the other half, the other group takes the other half. And it is eaten without salt. You take it without salt, and you drink a kind of local brew to escort the whole thing. And then they invoke the powers of the ancestors to intervene and cleanse the process. That is called Mato Oput. So once that is done, the last thing which is done is the burning of spears. Now, when spears are burned, that means we shall never fight again. So I think we still have room to explore the African traditional justice mechanism. Because of modern education, we are beginning to forget them. We need more studies, to be done. We need the media to expose some of this information. So it is work in progress.